The series of reading a book of constitution. Today I am going to talk about outstanding features of our constitution. The Constitution of India is remarkable for many outstanding features which will distinguish it from other constitutions, even though it has been prepared after ransacking all the known constitutions of the world. The most of its provisions are substantially borrowed from others, as Dr. Ambedkar observed. One likes to ask whether there can be anything new in a constitution framed at this hour in the history of the world. More than 100 years have rolled when the first written constitution was drafted. It has been followed by many other countries reducing their constitution to writing. Given these facts, all constitutions in their main provisions must look similar. The only new things, if there be any, in a constitution framed so late in the day are the variations made to remove the faults and to accommodate it to the needs of the country. So, though our constitution may be said to be a borrowed constitution, the credit of its framers lies in gathering the best features of each of the existing constitutions and in modifying them with a view to avoiding the faults that have been disclosed in their working and to adapting them to the existing condition and needs of this country. So if it is a patchwork, it is a beautiful patchwork. There were numbers in the Constituent Assembly who criticized the Constitution, which was going to be adopted as a slavish imitation of the West or not suited to the genius of the people. Many apprehended that it would be unworkable, but the fact that it has survived for more than 50 years while constitutions have sprung up only to wither away the countries around us, such as Burma and Pakistan, belies the apprehension of the critics of the Indian Constitution. Second, it must, however, be pointed out at the outset that many of the original features of the 1949 Constitution have been substantially modified by the 78 amendments which have been made up to 1996, of which the 42nd Amendment Act 1976 as modified by the 43rd and 44th Amendment Act 1977-78 has practically recast the Constitution in vital respect. The 73rd Amendment Act, which was brought into force in April 1993, has added 16 articles which provide for establishment of and elections to Panchayat. They comprise a new Part 9. By the same amendment, a new Schedule 11 has been added, which enumerates the function to be delegated to the Panchayat. The 74th Amendment Act was passed to establish municipalities and provides for elections to them. It has inserted Part 9A consisting of 18 articles. Schedule 12 inserted by the amendment mentions the functions to be assigned to the municipalities. This amendment came into force on 1st June 1993. Third, the Constitution of India has distinction of being most lengthy and detailed constitutional document the world has so far produced. The original Constitution contained as many as 395 articles and 8 schedules, to which additions were made by subsequent amendments. Even after the repeal of several provisions, it still in 2000 contains 442 articles and 12 schedules. A number of articles have been omitted. 64 articles and 4 schedules have been added to the Constitution, which Article 31A, 31C, 35A, 39A, 43A, 48A, 51A, 131A, 134A, 139A, 144A, 224A, 233A, 239A, 239AA, 239AB, 239B, 243, 243A to 243ZG, 244A, 257A, 258A, 290A, 300A, 312A, 323A, 323B, 350A, 350B, 361A, 363A, 371A, 371, 371I, 372A, 378A, 394A. The extraordinary bulk of the Constitution is due to several reasons. The farmers sought to incorporate the accumulated experience gathered from the working of all the known constitutions and to avoid all defects and loopholes that might be anticipated in the light of those constitutions. Thus, while they framed the chapter on the fundamental rights upon the model of the American Constitution and adopted the parliamentary system of government from the United Kingdom, they took the idea of directive principles of state policy from the Constitution of Ayr and added elaborate provisions relating to emergencies in the light of the Constitution of the German Reich and the Government of India Act 1935. On the other hand, our Constitution is more full of words than other constitutions because it has embodied the modified results of judicial decisions made elsewhere, interpreting comparable provisions in order to minimize uncertainty and litigation, not contented with merely laying down the fundamental principles of governance as the American Constitution does. The authors of Indian Constitution followed and reproduced the Government of India Act 1935 in providing matters of administrative details, not only because the people were accustomed to the detailed provision of that act, but also because the authors had the apprehension that in the present condition of the country, the Constitution might be perverted unless the form of administration was also included in it. In other words, in the words of Dr. Ambedkar, it is perfectly possible to pervert the Constitution without changing the form of administration. Any such superstitious subversion of the Constitution was sought to be prevented by putting detailed provision in the Constitution itself so that they might not be encroached upon without amending the Constitution. The very adoption of the bulk of the provisions from the Government of India Act 1935 contributed to the volume of the new Constitution inasmuch as the Act of 1935 itself was a lengthy and detailed organic law. So much was borrowed from that act because the people were familiar with the existing system. It was also felt that the smooth working of an infant democracy might be jeopardized unless the Constitution mentioned in detail things which were left in other constitutions to ordinary legislation. This explains why we have in our Constitution detailed provisions about the organization of the judiciary, the services, the public service commissions, elections, and the like. It is the same ideal of exhaustiveness which explains why the provisions of the Indian Constitution as to the division of powers between the Union and the states are more numerous than perhaps the aggregate of the provisions relating to the subject in the Constitution of USA, Australia, and Canada. The vastness of the country and the peculiar problems to be solved have also contributed towards the bulk of the Constitution. Thus, there is one entire part 16 relating to the scheduled caste and scheduled tribes and other backward classes, one part 18 relating to official language and another part 17 relating to emergency provisions, while the Constitution of United States deals only with the federal government and leaves the state to draw up their own constitution. The Indian Constitution provides the constitutions of both the Union and the units, that is the states, with the same fullness and precision. Since the units of the federation differed in their historical origins and their political development, special provisions for different classes of units had to be made, such as the Part B states representing the former Indian states, the Part C states representing the centrally administered areas, and some smaller territories in Part D. This also contributed the bulk of the 1949 Constitution. Though, as has just been said, the Constitution of a state was provided by the Constitution of India, the state of Jammu and Kashmir was accorded a special status and was allowed to make its own state constitution. Even all the other provisions of Constitution of India did not directly apply to Jammu and Kashmir, but depended upon an order made for the president in Constitution with the government of state, for which provision had to be made in Article 370, Chapter 15. Even after the inauguration of the Constitution, special provisions have been inserted, as for example Article 371 to Article 371I, to meet the regional problems and demands in certain states such as Nagaland, Assam, Manipur, Andhra Pradesh, Maharashtra, Gujarat, Sikkim and Mizoram, etc. Not only are the provisions relating to the units elaborately given, the relations between the federation and the units inter se, whether legislative or administrative, are also exhaustively codified so as to eliminate conflicts as far as possible. The lessons drawn from the political history of India, which included the farmers of the Constitution to give it a unitary bias, also prompted them to make detailed provisions regarding the distribution of powers and functions between the Union and its states in all aspects of their administrative and other activities, and also as regards interstate relations, coordination and adjudication of dispute amongst the state. There is not only a Bill of Rights containing justiciable fundamental rights of the individuals, Part 3 on the model of the amendments to the American Constitution, but also a Part 4 containing directive principle which confer no justiciable rights upon the individual, but are nevertheless to be regarded as fundamental in the governance of the country, being in the nature of principles of social policy as contained in the Constitution of Ireland, that is Republic of Ireland. It was considered by the makers of our Constitution that though they could not, owing to their very nature, be made legally enforceable, it was well worth to incorporate in the Constitution some basic non-justiciable rights which would serve as moral restraints upon future governments and thus prevent the policy from being torn away from the idea which inspired the makers of the organic law. Even the Bill of Rights, that is the list of fundamental rights, became bulkier than elsewhere because the framers of the Constitution had to include novel matters owing to the peculiar problems in our country, as for example untouchability, preventive detention. To the foregoing list, a notable addition has been made by the 42nd Amendment, inserting a new chapter of fundamental duties of citizens, Parts 4A, Article 51A, which, though not attended with any legal sanction, have now to be read along with the fundamental rights. Fourth, another distinctive feature of Indian Constitution is that it seeks to impart flexibility to a written federal constitution. It is only the amendment of a few of the provisions of the Constitution that requires ratification by the state legislatures. Even then, ratification by the 1/2 of them would suffice, while the American Constitution requires ratification by 3/4 of the states. The rest of the Constitution may be amended by a special majority of the Union Parliament, that is a majority of not less than 2/3 of the members of the Parliament of each house present and voting, which again must be majority of the total membership of the house. On the other hand, Parliament has been given the power to alter or modify many of the provisions of the Constitution by a simple majority, as is required for general legislation, by laying down in the Constitution that such changes shall not be deemed to be amendments of the Constitution. Instances to the points are changes in the names, boundaries, areas of, and amalgamation of and separation of states. Article 4, abolition or creation of the second chamber of the state legislature. Article 169, administration of scheduled areas and scheduled tribes. Para 7 of the 5th schedule and para 21 of the 6th schedule. The creation of legislatures and council of ministers for certain union territories. Yet another evidence of this flexibility is the power given by the Constitution itself to Parliament to supplement the provisions of the Constitution by legislation. Though the makers of the Constitution aimed at exhaustiveness, they realized that it was not possible to anticipate all exigencies and to lay down detailed provisions of the Constitution to meet all situations and for all times. This is the today's part of outstanding features of our Constitution. Thanks, regards.